Argument in CV 20-0264, Bickerton v. GUNN. Each side has, as usual, a maximum of 20 minutes for argument. You are not required to use all of that time, although you are welcome to do so. For the appellant, you may reserve some portion of your time for rebuttal, although despite the difficulty, you are responsible for managing your time and attempt to save some. Because we're handling the argument remotely, and we do thank you for accommodating us on that, I will be keeping a manual time clock, and I will alert you periodically of the time remaining. You should feel free to ask at any time, and you should also feel free to keep your own stopwatch or time record as we go. We are recording this argument. This recording will ultimately be posted to the court's YouTube channel, so for clarity of the record, please identify yourself and your client when you begin speaking. Now, of course, we hope that no connection failures occur, but should one of the judges lose connection, that judge will simply review the recording later. But if one of the attorneys loses the connection, we will, of course, suspend the argument until that connection can be regained. So keep in mind, we have read the briefing, we have studied the record, we've discussed the case in conference this morning, and with that, appellant, you may proceed.
Thank you and good morning. This is really a simple case from the appellant's standpoint. My client, the judgment creditors, filed a writ of garnishment, or had a writ of garnishment issued and served. Brooke Gunn filed an answer that was incorrect. My clients objected, and under ARS 12-1579A, we asked the trial court to compel a amended answer or a correct answer from the Gunns that contained, quote, true answers. The court stated at oral argument that Brooke Gunn was required to answer with a true answer, but the court's order ultimately did not require Brooke Gunn to file any sort of true answer as required under the statute. The case gets even easier because Ms. Gunn
Well,
Yes.
counsel, I assume Brooke Gunn believed the answer was true. I realize you dispute that, but she believed it to be true.
Yes, in fact, she signed under penalty of perjury that the answer was true. However, the answer said that she had no property belonging to Blake Gunn. And at trial, it came out that both at the first hearing and the second hearing, it came out that she did have property that belonged to Blake Gunn. She lives in a house with Blake Gunn. The house is her sole and separate property. She has access to his property. She has access to even property that she admits is non-exempt in her garage, and therefore her answer was incorrect.
Well, two things about that. The fact that she had access to it, does that mean that she has the property? I understand that Mr. Gunn lives there, so if he claims it as his property, even though she may have access to it, that doesn't mean that she possesses that property. And my second question is, what were the difficulties with the answer? Doesn't all that get washed away once the trial court has the hearing and takes evidence and makes whatever findings that it makes?
Okay. So to answer the first question, let's look at other garnishment scenarios. For instance, the garnishment of the safe deposit box allowed under Arizona law. The bank certainly doesn't have possession of the contents, does not even know what the contents of that safe deposit box are, and yet, and when I say have possession, I mean in the colloquial sense, but legally, the bank has the property because the property is in the safe deposit box at the bank. Similarly, this property was at Brooke Gunn's sole and separate house, and she had possession of it. In other contexts, of course, under Arizona law, possession is defined, for instance, as having the access to it or having control of it. And certainly we have that here with Ms. Gunn. Similarly, in other garnishment contexts, for instance.
Well, but in the context of the example you gave with the safety deposit box, the bank is in effect controlling it for the benefit of the owner of the contents, and there's an
Yes.
agreement to that effect. That's
Yes.
not necessarily the case. It's not necessarily the same as a person holding their property in a garage in a house where they reside, where someone else also resides.
Oh, due to the lack of a written agreement, yes, you're right. Other than that, I don't see the distinction. There's obviously a implicit social contract or agreement that that this property would not be disposed of by Brooke Gunn, that she wouldn't destroy it, etc. That she had possession of the property is clear in that respect. Similarly, in the context of a garnishment of a storage unit, the storage unit company does not even know the contents inside the storage unit, and yet there again is subject to a writ of non-earnings writ of garnishment regarding the contents in the storage unit.
But there
Counsel,
again, the company agrees to hold that property and to take possession of it and safeguard it for the benefit of the person who's paying them.
You have just under 15 minutes remaining.
Okay, thank you.
Isn't that a difference?
There is no difference between someone agreeing to hold property for purposes of the statute and 15 ARS 12-1579 does not ask the garnishee whether you're holding the property as a fiduciary. Doesn't even ask if you have the property legally. Read strictly, which is how the Arizona legislature requires the statute to be read, anyone with possession of the property has to answer this writ of garnishment, say what property they have, and then what property they're holding pursuant to the writ of garnishment. We can't read these extra words into the statute that say that it only applies to fiduciaries, which is not the case. The garnishment does not apply only to fiduciary garnishees. If so, it would ameliorate many garnishments throughout the state of Arizona that have been deemed legitimate and will be in the future.
So
Well,
let's move on. Okay, go ahead. Go ahead.
Well, I don't think you would need to be that extreme. Are you saying that if Mr. Gunn didn't live at the house and came to visit and parked the car in the garage, then she would have possession of the car at that point?
So yes, absolutely. The only exception to that would be if he parked the car in the garage as a true trespasser without her knowledge, consent, implicit consent, or and just absolute hostile to her. Anytime someone takes possession of property, whether it's as a mere bailee picking something up, not knowing who it belongs to, or having possession of someone else's property in their garage, they owe a duty to the judgment creditor to explain that in connection with ARS 12-1579. I'll give you one example. For instance, when I toured the house of the Gunns, I noticed that there was this movie room. It was quite nice, and the projector was missing. And I asked, well, where's the projector? And Mr. My distinguished colleague, opposing counsel, looked into it and came back and said that, well, the Gunns lent the projector to a relative. If we had served the garnishment on that relative who was borrowing the projector, of course the relative would need to respond with the explanation that, yes, I'm holding property that belongs to the Gunns and turn over the projector. which is what that is meant to cover. Here, this case is all the more easy because Ms. Gunn specifically consented to have her community property used to satisfy the judgment against Mr. Gunn. Ms. Gunn agreed that the judgment shall be effective against the Gunn marital community, and she will not assert a defense in future collection proceedings that the judgment is not a community debt or that the judgment may not be collected from community property. And that's important to remember because that is a form of estoppel and something that actually is being asserted here in the response to the appellate brief. So Ms. Gunn has violated that spousal consent because she's argued at the trial court and in this appeal that the judgment cannot be collected from the Gunn's community property.
Because
Yep, go ahead.
Because according to her, she did not have non-exempt property.
Actually, according to her, she admitted both at the trial court and then in response to our appellate brief that she did have non-exempt property in the form of camping gear, scuba equipment, etc. She also provided no testimony regarding the value of the exemptions. And I'd like to talk about the exemptions because this exemption statute is new or fairly new.
Counsel, you have 10 minutes left.
Okay, thank you. ARS, I'm just going to say as one example of the exemption statutes, the exemption statutes are worded in such a way that certain categories are exempt up to an amount of, for instance, $6,000. ARS 33-1123 provides household furniture and furnishings, household goods, including consumer electronic devices and household appliances, personally used by the debtor or a dependent of the debtor, and not otherwise specifically prescribed in this chapter are exempt from process, provided their aggregate fair market value does not exceed $6,000. Now, this is a departure from how the exemption statutes were reading in the past, which would specify you get one armchair, you get one rocking chair, you get one TV, you get and it was very more there was more numbers to specific items that were exempt. Now with this dollar amount, frankly, the sheriff does not know how to execute on a writ of general execution when there hasn't been first a writ of garnishment. You see, going through the process to be able to specify what of the $6,000 valuation is going to be picked up by the sheriff and what is not. But in answer to your question, once again before, there's no question here that the scuba equipment, at a minimum, the scuba equipment and the camping gear are non-exempt, they're valuable, and they should have been listed. Now, also remember under 12-1579, all the property needs to be listed, regardless if the property is being held or not held. The property might not be held because it's exempt, but without listing the property, the judgment creditor cannot challenge whether a property is or is not exempt. And that is another deficiency here. If there's any more questions on that point, I'd like to address them. Otherwise, I'd like to save the remainder of my time for rebuttal.
Thank you, counsel. You have 7.5 minutes left.
Thank you.
Proceed when you're ready.
Well, thank you, Your Honor. I was waiting for you to say that. May it please the court and counsel, Thomas Littler representing garnishee defendant Brooke Gunn. I disagree with Mr. Brower that this was a simple case in that they chose a unique method of trying to execute on a unique judgment. As you know from the briefing, the judgment is not against Brooke Gunn. She just simply signed a spousal consent saying that I will not object if you execute against the community property, which she hasn't objected to that, but there's nothing in there waiving any exemptions that she has. But then they took the additional step of garnishing and not just sending a writ of general execution to the Gunns to try to find out what it was. And a garnishment is a unique proceeding, and we pointed out in our briefs that typically it's against a third party, and the rules seem to contemplate that it'll be a third party. It's not required to be a third party, but I think that's what the rules contemplate, is that it'll be a third party then saying I possess or don't possess property of the judgment debtor. And that's where, in preparing this answer, it became somewhat problematic, because as I've learned long ago, someone wiser than me probably taught me that words matter. And when you're answering a complaint, you need to evaluate what those words are. And the words here in the writ itself, the writ of garnishment, were you holding any personal property or money belonging to Blake Gunn, the judgment debtor, who was defined as the judgment debtor, Blake Gunn was. How much money do you owe Blake as the judgment debtor? And did you possess any personal property belonging to Blake? Counsel in the answering brief, and I believe in the reply brief as well, suggested that I've conceded that our answer was incorrect. I did not do that and will not do that today. I believe that the answer to the garnishment is still correct in this day as we interpret those words, holding, belonging, and possessing. As Judge Howe pointed out, access to isn't the same as possession. And we couldn't find any authorities on this one way or another, but if you have two people living in the same household and one has property and the other one has property, is it in the possession of one or the other simply because the other one has it? I mean, that sounds confusing, and that's sort of the issue that we were faced with in preparing this answer. And it becomes even more complicated when the judgment debtor is described as Blake Gunn, but not Blake Gunn and his marital community, so that they, as members of the community, Brooke Gunn has an undivided interest in property. I mean, I was thinking, it's like I have this coffee cup. My wife and I have been married for over 20 years. Am I possessing her property by holding this coffee cup? What if it's sitting in the cupboard? Am I possessing it because we live together in a house? I don't believe so. But I don't think that really matters, because at the end of the day, what happened here was they got their hearing that was required under the garnishment statutes. And what this case really turned into, Your Honors, was what it should have been all along, which is a writ of general execution against personal property held by the Gunns. And when you add all the discovery that they had done, and that's why we gave you an overlong explanation of the history of this case and the discovery. When you add to that what we allowed them to do, which was a unique procedure where they went through the Gunn's house, taking pictures of property and inventorying every dish, every spoon, every appliance, and then submitting lists to the court and having a trial on those lists, what difference would it make what was said in the answer? Because they've had their hearing and the judge made a decision of fact that there was no non-exempt property. Now, I did have an interaction with the commissioner, and that interaction, yes, Your Honor.
Okay, so is the bottom line is yes, she had access, perhaps she possessed property of her husband, but whatever property she did access or possess was was exempt. Is that the bottom line?
Yes, except for this one issue regarding the scuba equipment. And the scuba equipment was being held for the sheriff because they had also sent a writ of general execution to Mr. Gunn. And he had assembled the scuba equipment, which arguably, we don't concede it, but arguably was not exempt, in the garage, and it was being held for the sheriff to pick it up after he had inspected the house. He never picked it up, but that's a different story. But yeah, it was being held. There was just the scuba equipment. That was it. But she wasn't holding that, and maybe it wasn't exempt, but it was in the garage being held for the sheriff. So other than the scuba equipment, yes, everything there was exempt as the judge found as a finding of fact. That answer your question, Judge Howe?
Yes, thank you.
Okay.
You have about 14 and a half minutes.
Thank you, Your Honor. Yeah, I am actually keeping track like I do my daughter's speech and debate team.
Super.
So I'm used to that. So yeah, and we think that's really important because in the end of the day, they had a full and complete hearing, and Judge, the commissioner has said something about striking the answer and requiring us to refile it, and asserting that that was a normal procedure. So anything I said in the record was trying to find a solution to the problem of her thinking that she had some right to strike the answer simply because it was incorrect, which I will assert to you, I think is not consistent with proper procedure.
But counsel, isn't the correctness or incorrectness of the answer really by the board once the hearing occurs and evidence comes in and the judge makes whatever findings the judge makes? Isn't the correctness of the answer not matter at that point?
Yes, Your Honor. If I filed an answer in general civil litigation and denied existence of a contract and denied damages, and then we have a trial and the judge finds yes, there was a contract and yes, the other side was damaged, they don't go back and strike my answer. They simply enter judgment. And that's why in this case, in the garnishment statutes, there's very limited relief allowed if the court finds that there is non-exempt property being held by the garnishee defendant. And that's 1585 for the property because there was no evidence that there was any money being withheld. And that is simply to have this property set aside and held for the sheriff. But in our case, the evidence was it was already being held for the sheriff. It was being held in the garage, the scuba equipment, the non-exempt property. The only thing that could have been consistent with the evidence, subject to an order to be held and set aside for the sheriff to be picked up, was the scuba equipment, and it was already being held. So everything else she found, there was no non-exempt property.
Counsel, if I might ask about how the exemptions work, is that, correct me if you have a different view of this, but I read the exemptions that are statutorily provided for, and they either exist or they don't exist. And there's a lot of argument in the briefing over whether the exemptions are claimed or not claimed. But that really doesn't matter, does it?
No, it doesn't. I mean, it doesn't under the exemption laws or under the garnishment laws. The court still has to find whether they're exempt or not, whether they're claimed or not. But I want to raise another point. I'm not sure this is clear from the briefing. You know, the process of the garnishment is that a third party typically says, yeah, we have this property. Let's say we're holding, let's say cash. The bank says we're holding this property. Then the judgment debtor comes in and says, wait, I object to that because I claim it's exempt. There's no real provision here for someone asserting exemption when the garnishee defendant says, I'm not holding any property to be turned over. So even though I also disagree that this is like Judge Howe was just pointing out, that you have to assert the exemption or you lose it in those 10 days, there was nothing for the judgment debtor here to do because Brooke Gunn, as the garnishee defendant, didn't say she was holding any property. And in any event, they got their relief by asking for a hearing and then having the hearing and then having the judge decide that there was no non-exempt property. The procedure followed exactly. It just started off in a very different kind of unique situation. I think that's all on the issue of the writ and the answer. One of the things regarding the answer that the appellant seems to misunderstand is even during the discussions of the judge striking the answer, we were simply she was going to allow us to file a new answer, which if we filed a new answer, all we would have done is written out a lot more stuff and attached the list and the exhibits that we had at the trial. And at that point, if they objected because that evidence was already in trial and ruled upon, I think it would have been bad faith. So it was like a futile act to strike the answer and have us file a new one with all the information that they had as a result of the trial. Let's see. One of the things that we're a little confused about from the appellee's side is this request in both the conclusion for in the opening brief as well as the reply brief that the court sends the case back and remand it with instructions to enter this Exhibit A. And this Exhibit A is a finding of fact and conclusion of law that was never asked for prior to the hearing, was never asked for during the hearing, and it contains all kinds of facts that are inconsistent with the rulings of the judge. So they're asking you to order her to issue findings of fact inconsistent with her findings. So I don't believe that's appropriate. They're also asking you for relief that she denied, and they're asking you to reverse her decision that there was no fraudulent transfer in this case, and asking you to order that the house be sold. We believe that that is all inappropriate, beyond what this court should be doing, and certainly inconsistent with the issues on this appeal. In fact, we don't believe that the Uniform Fraudulent Transfer Act issues are even raised in this appeal appropriately. So that relief certainly is extra or beyond what we think the court should be doing. I could just have one moment to just look at my notes. Yeah, unless the court has any further questions, even though I have about 7 minutes left, I think at this point we rely upon our briefs and submit the case based upon our briefs and the argument.
I have nothing.
All right, thank you, counsel.
Thank you.
Let me set up the clock here. I show 7 minutes, 35 seconds remaining for you, Mr. Brower.
Thank you, Your Honor. There's several points I'm going to try to get through quickly. Allowing a garnishee to answer with disregard for ARS 12-1579 invites mischief. Judgment debtors do not want to pay, and their spouses don't want them to pay either. It's just a fact of life. Cohabiting partners also don't want their cohabiting partner to pay. If a cohabiting partner owns a garage that contains property that belongs to his or her partner, that's subject to garnishment. If a married couple, if the spouse has property in her sole and separate garage, then it's subject to garnishment. Just as a garnishee's truthful answer allows a judgment creditor to object to the answer. For example, if the garnishee states that it has property of the judgment debtor, but it's not holding the property for the judgment creditor for whatever reason, the judgment creditor can then file an objection and request that the
Well, counsel, I'll ask you. I think I asked you this, and then I asked the other counselors. We keep talking about the answer, but the answer, at least it seems, doesn't matter now once the hearing occurs and findings of fact are made. You know, the findings may be wrong, they may be without sufficient evidence. That's a different issue. But whether the answer is good or bad at this point, it doesn't matter. Am I looking at that incorrectly?
Yes, Your Honor, with due respect, you are, because when a judgment creditor objects to an answer, if the judgment creditor is deemed to be wrong, the judgment creditor has to pay attorney's fees. When the judgment creditor receives an answer that says, we're not holding any property, but only has to, like pulling teeth, like a dentist pulling teeth, get bits and pieces of information out through several trials and through a laborious process like here. And then if it turns out that that judgment creditor is wrong, what was the judgment creditor supposed to do? Not object to the answer. And yet the statute and the practice of the commissioners will award attorney's fees against that judgment creditor under those circumstances. So it is unduly punitive to force the judgment creditor to object to the garnishment answer and then later say, well, the answer's been cured, so the judgment creditor loses. The judgment creditor must win.
Well, then, if you have issues with the answer that you don't want to be resolved at the hearing, isn't it your responsibility to follow a special action? Because it seems to me, once the hearing occurs, the answer, good or bad, it doesn't matter.
No, there's the one process that the legislature has set out for disputing the completeness of an answer is found in the statute. It doesn't say anything about bringing a special action, and it doesn't say anything about asking for bringing a motion for clarification or any of that. And of course, because the garnishment statutes and the procedures have to be strictly complied with, hence, for instance, the garnishment statutes being struck down as unconstitutional, and the new garnishment statutes with the timelines, the expedited timelines, needing to be strictly complied. There's no way to take issue with that sort of thing without exposing a judgment creditor who's owed millions of dollars on a Ponzi scheme here to object to the sufficiency of an answer without exposing them to an award of attorney's fees, which would happen if this honorable court were to rule that an answer can be merely cured by, I guess, deposition or trial testimony. And the fact is that the judgment creditor is entitled to, at a minimum, the answers under oath. Remember, under oath, found in to the questions found in 1579 in order to go to the hearing. This is not an absolute trial by ambush or trial by surprise in that respect. So the judgment creditor did the only thing that the judgment creditor could do, object to the answer as being absolutely incomplete. It is clear that the answer is incomplete. Not only have several of the questions never been answered, but also the answer that was given was clearly wrong. And the judgment creditor has to be seen as the successful party so as to avoid a claim for attorney's fees by the judgment or the garnishee who was in the wrong. The judgment creditor was not in the wrong. If the garnishee does not provide a true answer, the issues are not narrowed for the court, which wastes precious judicial resources, especially since these hearings are supposed to be done on an expedited basis, and the parties lose the opportunity for a prompt hearing and resolution. And as stated before, the primary reason why the legislature amended the garnishment statutes in 1986 after the garnishment statutes were struck down as unconstitutional was for that promptness and the efficiency.
You have 2 minutes left.
Thank you. And the legislature would not have created such a detailed regimen if it did not intend for garnishees to comply with the specific provisions in the garnishment statute. In the last 2 minutes, I wanted to read something. The court should not permit judgment debtors to continue to treat the legal system as a game. The judges, your honors, you've seen the procedural history, you've seen the attempts to collect on this judgment, which is a judgment of the honorable court of the superior court. Here, Justice Berger in 1970 said, a sense of confidence in the courts is essential to maintain the fabric of ordered liberty for a free people. And 3 things could destroy that confidence and do incalculable damage to society. First, that people come to believe that inefficiency and delay will drain even a just judgment of its value. Yet, your honors, this is a simple matter in the sense that this should just be a routine property garnishment. Here we are on appeal dealing with these things when the answer was clearly wrong. This is the sort of inefficiency and delay that Justice Berger advised and was concerned about. A debtor that can make payments on a court-ordered judgment, but instead hires lawyers or does things to kind of thwart and delay enforcement of the judgment is not a friend to the court. that person is an enemy to the fair judicial process, especially in connection with such a simple matter as a garnishment of personalty. In sum, Ms. Gunn violated ARS 12-1579A when she falsely denied possession of any personal property that belonged to Mr. Gunn. As pointed out by the Gunns in their response brief, the marital community, well,
Counsel, your time has expired.
Thank you, Your Honors.
Thank you both for your arguments. We appreciate your accommodation and your preparation. We will take the matter under advisement and issue our decision in due course. And with that, our court stands in recess.
Thank you, Your Honor.
Thank you.